Cornell Law School. UCC, Article 2, Sales. Part 5. Performance. Paragraph 2509. Risk of loss in the absence of breach. 1. Where the contract requires or authorizes the seller to ship the goods by carrier, A. If it does not require him to deliver them at a particular destination, the risk of loss passes to the buyer when the goods are duly delivered to the carrier, even though the shipment is under reservation. Section 2505. But, B. If it does require him to deliver them at a particular destination, and the goods are there duly tendered while in the possession of the carrier, the risk of loss passes to the buyer when the goods are there duly so tendered as to enable the buyer to take delivery. 2. Where the goods are held by a bailee to be delivered without being moved, the risk of loss passes to the buyer, A. On his receipt of a negotiable document of title covering the goods, or, B. On acknowledgement by the bailee of the buyer's right to possession of the goods, or, C. After his receipt of a non-negotiable document of title or other written direction to deliver, as provided in subsection 4b of section 2503. 3. In any case not within subsection 1 or 2, the risk of loss passes to the buyer on his receipt of the goods if the seller is a merchant, otherwise the risk passes to the buyer on tender of delivery. 4. The provisions of this section are subject to contrary agreement of the parties and to the provisions of this article on sale on approval, section 2327, and on effect of breach on risk of loss, section 2510. Paragraph 2510. Effect of breach on risk of loss. 1. Where a tender or delivery of goods so fails to conform to the contract as to give a right of rejection, the risk of their loss remains on the seller until cure or acceptance. 2. Where the buyer rightfully revokes acceptance, he may, to the extent of any deficiency in his effective insurance coverage, treat the risk of loss as having rested on the seller from the beginning. 3. Where the buyer is to conform in goods already identified to the contract for sale repudiates or is otherwise in breach before risk of their loss has passed to him, the seller may, to the extent of any deficiency in his effective insurance coverage, treat the risk of loss as resting on the buyer for a commercially reasonable time. Paragraph 2511. Tender of payment by buyer. Payment by check. 1. Unless otherwise agreed, tender of payment is a condition to the seller's duty to tender and complete any delivery. 2. Tender of payment is sufficient when made by any means or in any manner current in the ordinary course of business, unless the seller demands payment in legal tender and gives any extension of time reasonably necessary to procure it. 3. Subject to the provisions of this Act on the effect of an instrument on an obligation, Section 3802, payment by check is conditional and is defeated as between the parties by dishonor of the check on due presentment. Paragraph 2512. Payment by buyer before inspection. 1. Where the contract requires payment before inspection, nonconformity of the goods does not excuse the buyer from so making payment unless A. The nonconformity appears without inspection, or B. Despite tender of the required documents, the circumstances would justify injunction against honor under the provisions of this Act, Section 5114. 2. Payment pursuant to subsection 1 does not constitute an acceptance of goods or impair the buyer's right to inspect or any of his remedies. Paragraph 2513. Buyer's right to inspection of goods. 1. Unless otherwise agreed and subject to subsection 3, where goods are tendered or delivered or identified to the contract for sale, the buyer has a right before payment or acceptance to inspect them at any reasonable place and time and in any reasonable manner. When the seller is required or authorized to send the goods to the buyer, the inspection may be after their arrival. 2. Expenses of inspection must be borne by the buyer but may be recovered from the seller if the goods do not conform and are rejected. 3. Unless otherwise agreed and subject to the provisions of this article on CIF contracts, subsection 3 of Section 2321, the buyer is not entitled to inspect the goods before payment of the price when the contract provides A. for delivery, COD or on other like terms, or B. for payment against documents of title, except where such payment is due only after the goods are to become available for inspection. 4. A place or method of inspection fixed by the parties is presumed to be exclusive, but unless otherwise expressly agreed, it does not postpone identification or shift the place for delivery or for passing the risk of loss. If compliance becomes impossible, inspection shall be as provided in this section unless the place or method fixed was clearly intended as an indispensable condition, failure of which avoids the contract. Paragraph 2514. When documents deliverable on acceptance, when on payment, unless otherwise agreed, documents against which a draft is drawn are to be delivered to the drawee on acceptance of the draft if it is payable more than 3 days after presentment, otherwise, only on payment. Paragraph 2515. Preserving evidence of goods in dispute. In furtherance of the adjustment of any claim or dispute, A. either party on reasonable notifications to the other, and for the purpose of ascertaining the facts and preserving evidence, has the right to inspect, test and sample the goods, including such of them as may be in the possession or control of the other, and B. the parties may agree to a third-party inspection or survey to determine the conformity or condition of the goods, and may agree that the findings shall be binding upon them in any subsequent litigation or adjustment.